Hello everyone, welcome back to our channel Beyond the Briefcase. So, in the previous video, we discussed about the fundamental elements of crime, but it has four elements, and we discussed only about two. That was first person, and second one was actus reus or act. So now, in this video, that is the part two of fundamental elements of crime. We will discuss about the third and fourth elements of a crime. That is first one mens rea and the second one injury. Now we will move on in this video with the third element, that is mens rea, that is the mental element in a crime. So in the four elements of crime, this is the most important element of crime. So what does mens rea basically means? So mens rea in simple terms means a guilty mind. So this term basically means that the intention should be malified in nature. That is, it should not be for a public good, and it must be forbidden by law. Must not be for public. So to understand the concept of mens rea, we must understand these two terms. That is, first one is state of mind, and the second one is it should be forbidden by law. So what does state of mind means? State of mind means the intention when he commits the crime. What is the intention behind that act? So it basically means the intention. It should be a malified intention. That is, it should be a malified intention. And that intention should be forbidden by the law. When these two elements are combined together, then the element of mens rea is constituted. So the term mens rea has not been defined under the IPC previously or in the BNS, but the term mens rea has been incorporated under section 2 clause 33 of BNS under the definition of voluntarily. So what does this section states? So basically the section states that a person is said to cause an effect voluntarily when he causes it by means whereby he intended to cause it, or by means which at the time of employing those means he knew or had reason to believe to be likely to cause it. So basically under the section 2 clause 33 there are three elements. First one is intention, that the person knew that it would cause a harm to the other person or party. That is, it basically means 100% surety of the result. The second element in the section was knowledge. He knew that the act will cause harm to the other person. So it basically means 100% certainty. And the third one is reason to believe. It basically means that he had the reason to believe that the act will cause some harm to the other party. These two elements, that is the intention or the knowledge or the reason to believe, should be considered while determining the quantum of punishment for an offense. Now, we would discuss some of the exceptions to the concept of mens rea. First one is insanity. That is, if a person is insane, then his intention to commit a crime should not be considered while determining the offense. Second one is offenses against the state. In this case also, the intention should not be considered. Third one is offenses against the woman. These offenses are considered heinous in nature. That's why it is considered as an exception to the concept of mens rea, such as the offense of rape, etc. Offenses against state may include the offense like sedition, etc. Fourth one is ignorance of the law. In this case also, the intention is not considered. And the fifth one is act of a child. Up to 7 years of age. So these 5 were the exceptions to the concept of mens rea, and now we will discuss a case law to understand the concept of actus reus and mens rea in combination. So in the case of State of Maharashtra versus M.H. George 1963, the Supreme Court has laid down that the fundamental principle of criminal liability is that there must be a wrongful act. That is the actus reus plus that it must be combined with a wrongful intention. That is the mens rea. So basically it means that the wrongful act plus wrongful intention must be there to constitute a crime. That is, there should be actus reus and there should be mens rea also to constitute a crime. The last fundamental element of crime is injury. So the last element, that is injury, has been defined under section 2 clause 14 of BNS. So it basically states that any illegal harm caused to body, mind, reputation or property is known as injury. So what does illegal means? Illegal simply means anything which is forbidden by the law. Or we can say that it is contrary to law. Injury also includes any tortious act. That is, it is not confined to the criminal act only. We have discussed all the fundamental elements of crime. So the first one was person. In simple words, it means ABC, that is an association, body of persons, and C, company. Second one was actus reus, that is the act itself, which should be wrongful and forbidden by law. Third one was mens rea, or the guilty mind. Or we can say that the wrongful intention. And the last one was injury, which included any illegal harm to body, mind, reputation, or property. So I hope you have understood the fundamental elements of crime clearly, and thank you for watching the video.